She had a mere 180 seconds to steer clear of jail. What Judge Beryl Howell was unaware of was that she had just issued a threat to the wrong Congresswoman. Congresswoman Crockett, I am finding you in contempt. You have 3 minutes to explain why I shouldn't order the marshal to take you into custody this very moment. The whole courtroom went silent. The most formidable federal judge in Washington had just threatened to imprison a sitting member of Congress. But then, no one anticipated what came next. Not the prosecutors, not the defense, and certainly not Judge Howell. Your Honor, before you exercise that authority, you should know that the Supreme Court has ruled in 3 different cases that what you're attempting to do is unconstitutional. In the next 90 seconds, Congresswoman Jasmine Crockett not only avoided being jailed, she completely reversed the situation on one of America's most powerful judges. And by the conclusion of the session, that very judge who wanted her locked up was practically seeking her legal guidance. This isn't merely another courtroom drama. This is the tale of what unfolds when firm knowledge encounters unchecked power, and why everyone who values justice needs to see what happened next. Hit like and subscribe now to witness how this legal genius transformed a jail threat into one of the most remarkable courtroom wins in recent memory. The full story will leave you completely astonished. Judge Beryl Howell had established her reputation for being one of the toughest federal judges in Washington, D.C. Appointed to the U.S. District Court for the District of Columbia in 2010, she had previously served as chief judge from 2016 to 2023. Her background as a former federal prosecutor and Senate Judiciary Committee counsel gave her a profound understanding of criminal procedure and a reputation for having little tolerance for those who appeared unprepared in her courtroom. At 67, Judge Howell carried herself with a confidence that stemmed from decades of legal expertise. Her silver, gray hair was always impeccably styled, her black robe flawlessly pressed. Known for her sharp questions and occasional sarcastic remarks to lawyers who tested her patience, she demanded respect and, frankly, a good amount of fear from those who appeared before her. The judge had overseen numerous high-profile cases during her time on the bench, from political corruption trials to national security matters. Legal analysts often described her as meticulous, thorough, and at times intimidating. Defense attorneys would privately complain that she favored the prosecution, though few would say so publicly for fear of facing her anger in future cases. In recent years, Judge Howell had become increasingly protective of the court's dignity, showing particular frustration toward what she saw as political interference in judicial matters. She had disciplined several attorneys for making public statements about ongoing cases, and her contempt powers were not used sparingly. Congresswoman Jasmine Crockett represented a different kind of legal authority. At 43, the freshman representative from Texas had already built an impressive career before entering Congress in 2023. What wasn't widely known outside legal circles was that before running for office, Crockett had specialized in civil rights law and, crucially, had extensive experience challenging judicial overreach. After graduating with honors from the University of Houston Law Center, Crockett had spent years defending clients against systemic injustice. She had successfully argued before the Texas Supreme Court and had won several landmark cases involving judicial misconduct. She had also written a well-regarded law review article titled "Constitutional Guardrails: The Proper and Improper Use of Judicial Contempt Powers." Crockett had come to observe the proceedings in Judge Howell's courtroom because of a controversial case involving First Amendment protections for political speech. The case had implications for legislation she was working on in Congress. Her presence was not as legal counsel, but as an observer with a specific interest in the constitutional questions being debated the day before. Following a controversial ruling that limited key defense evidence, Crockett had been approached by reporters outside the courthouse. Her comments had been thoughtful but direct. While I respect the court's authority, today's ruling appears to disregard established precedent on protected political speech. The selective application of First Amendment standards raises serious questions about the decision-making process in these proceedings. Those carefully selected words spoken by a sitting member of Congress with significant legal credentials had apparently angered Judge Howell, leading to the confrontation now unfolding in her courtroom. Have you ever witnessed someone hold their ground when faced with an authority figure who went too far? Share your experiences in the comments below. We'd love to hear how you handled similar situations. The tension in courtroom 22 was palpable as proceedings began that Friday morning. The grand wood, paneled room with its high ceiling, an imposing bench seemed designed to remind everyone of the judge's authority. Sunlight streamed through tall windows, lighting up dust particles floating in the air and casting dramatic shadows across the marble floor. Judge Howell entered precisely at 9:00 a.m., her face stern as she looked over the packed gallery. Reporters filled the front row, notebooks ready. Legal observers, law students, and curious members of the public occupied every available seat. Court security officers stood at attention, sensing the unusual tension in the atmosphere. Before we proceed with today's scheduled matters, Judge Howell began, her voice carrying that distinct tone of judicial authority. There is a preliminary issue I need to address. She fixed her gaze directly on Congresswoman Crockett, who sat in the second row of the gallery. Representative Crockett, please approach the podium. A ripple of whispers spread through the courtroom as Crockett, dressed in a tailored navy suit with a single strand of pearls, rose calmly and walked to the center of the courtroom. Unlike others who typically appeared nervous when singled out by Judge Howell, Crockett's demeanor remained composed and professional. Congresswoman Crockett, Judge Howell continued, I have been made aware of statements you made to the press yesterday regarding my ruling in the United States v. Marson case. Your comments suggested that this court has applied First Amendment standards selectively and questioned the integrity of the decision-making process in this court. The judge's voice grew harsher. Such statements, particularly from an attorney and member of Congress, risk undermining public confidence in these proceedings and could constitute contempt of court. I am considering sanctions, including possible detention, until a formal apology is issued. The courtroom became completely silent. The court reporter's fingers moved quickly across her stenotype machine, capturing every word of what was quickly becoming an extraordinary confrontation. Before I make that determination, Judge Howell continued, you have 5 minutes to explain why I should not find you in contempt. Crockett nodded once, opened her leather portfolio, and began a response that would completely alter the dynamics of power in that courtroom. Thank you, Your Honor, she began, her voice clear and respectful, yet steady. Before addressing the specific allegations, I'd like to clarify my capacity here today and the legal standards that govern this situation. Judge Howell leaned forward slightly. Congresswoman, I'm well aware of who you are. What concerns me is your commentary undermining this court's authority. I understand, Your Honor, Crockett replied, and that goes directly to my first point. I am not appearing before you as counsel in this case. I am here in two distinct capacities, as a member of Congress with constitutional oversight responsibilities regarding our judicial system, and as a licensed attorney with specific expertise in the constitutional limitations on contempt powers. Crockett reached into her portfolio and removed a document. With the court's permission, I've prepared a brief memorandum addressing the legal standards for contempt in this precise context. After a moment's hesitation, Judge Howell nodded. You may approach. As the judge reviewed the document, Crockett continued, Your Honor, the Supreme Court has established clear guidelines for when commentary on judicial proceedings crosses into contemptible territory. In Bridges v. California, the court held that such sanctions are appropriate only when comments pose a clear and present danger to the administration of justice. Judge Howell looked up, her face still stern, but with a hint of caution now. I'm familiar with the case law, Congresswoman. Your statements questioned this court's impartiality and application of constitutional standards. With respect, Your Honor, Crockett responded, my actual statement was that the selective application of First Amendment standards raises serious questions about the decision-making process. That's a substantive legal observation about inconsistent application of constitutional principles, not an attack on the court's integrity. She removed another document from her portfolio. I've included the full transcript of my remarks to the press. You'll note that I prefaced those comments by expressing respect for the court's authority. As Judge Howell reviewed this second document, the atmosphere in the courtroom subtly changed. Several legal observers exchanged glances, recognizing that Crockett was mounting a sophisticated defense rarely seen in contempt proceedings. "Even if I accept your characterization," Judge Howell said, her tone slightly less certain, "public statements that question a court's application of constitutional standards can still interfere with proceedings by influencing public opinion." Crockett nodded respectfully. "That brings me to my third exhibit, Your Honor." In Landmark Communications versus Virginia, the Supreme Court specifically addressed the constitutional protection for commentary on judicial proceedings, particularly by public officials with oversight responsibilities. She presented a third document, which the judge accepted with a slight frown. Furthermore, Crockett continued, in Standing Committee versus Yagman, the Ninth Circuit held that an attorney's criticism of a judge is protected speech, unless it was both objectively and subjectively a false statement of fact. My comments were neither false nor presented as factual assertions about your motives. They were legal observations about the consistency of rulings with established precedent. The courtroom remained absolutely silent as Judge Howell reviewed the materials. Even the prosecutors seated at their table to the left appeared to be reconsidering the situation. Crockett wasn't finished. "Your Honor, I've included as my fourth exhibit my own legal credentials and expertise in this specific area of law. I've successfully litigated 3 cases before the Texas Commission on Judicial Conduct involving the limits of contempt power and authored a law review article on this precise constitutional question." This revelation caused several journalists to frantically jot down notes. Judge Howell's expression had now visibly changed from stern confidence to careful reconsideration. "And finally, Your Honor, I've included as my fifth exhibit the transcript from United States v. Rodriguez, a 2019 case in which you yourself noted, and I quote, "A thoughtful criticism of judicial decisions, even strong criticism, serves an important function in our legal system and rarely rises to the level of contempt, absent direct interference with court operations." A faint murmur rippled through the gallery before being silenced by a sharp look from a court security officer. Judge Howell stared at the document, clearly surprised by Crockett's knowledge of her own prior rulings. "Your Honor," Crockett said, her voice still respectful, but now carrying a quiet authority that commanded the room's attention. "I stand by my comments as legally accurate, constitutionally protected, and consistent with my responsibilities, both as an attorney and as a member of Congress." They were measured observations about constitutional application, precisely the kind of good, faith legal commentary that you yourself have recognized as legitimate in previous cases. She closed her portfolio and stood straight, looking directly at the judge. "Unless the court finds that my comments posed a clear and present danger to these proceedings, a standard that requires specific evidence of harm rather than general concerns about propriety, the Constitution and this court's own precedent do not support a finding of contempt." The silence that followed was profound. Judge Howell stared at the documents before her, then at Congresswoman Crockett, clearly reevaluating her approach. What had started as a routine exercise of judicial authority had turned into something far more complex. After a long moment, Judge Howell spoke. "I'll need time to review these materials more thoroughly. This court will take a 15-minute recess." With that, she rose and exited to her chambers, leaving the courtroom buzzing with whispered conversations about what had just happened. The 15-minute recess stretched to 30 minutes as Judge Howell remained in her chambers. When she finally returned, the courtroom immediately fell silent again. The judge's demeanor had noticeably changed. Her earlier certainty was replaced by a more measured approach. She adjusted her glasses and looked directly at Congresswoman Crockett, who had remained standing at the podium during the recess. Her posture was perfect, her expression calm. "Congresswoman," Judge Howell began, her tone noticeably more friendly, "I have reviewed the materials you provided, as well as the full transcript of your statements to the press. Before ruling on this matter, I want to acknowledge several points." She glanced down at her notes. "First, I recognize that your comments were more nuanced than initially characterized. You did indeed preface your remarks with an expression of respect for this court's authority." Crockett nodded slightly, but remained silent, allowing the judge to continue her reassessment without interruption. "Second, Your legal analysis regarding the constitutional standards for contempt is comprehensive and well supported. The cases you've cited establish a high threshold for sanctioning commentary on judicial proceedings, particularly from public officials with oversight responsibilities. The judge paused, seeming to carefully consider her next words. Third, I must acknowledge that your expertise in this specific area of law is substantial and directly relevant to the question before us today. A murmur of surprise rippled through the courtroom. It was unusual for a judge, particularly one with Judge Howell's reputation, to publicly acknowledge being taught the law by someone appearing before them. In light of these considerations, Judge Howell continued, I am withdrawing the contempt warning. Your comments, while critical of certain rulings, did not cross the constitutional threshold for sanctions as established by the Supreme Court. The gallery remained silent, but the shift in energy was palpable. What had begun as a power dynamic, completely in the judge's favor, had transformed into something approaching a discussion between legal equals. But Judge Howell wasn't finished. What she said next surprised everyone in the courtroom. Congresswoman Crockett, while this concludes the contempt matter, your submissions have raised important questions about the First Amendment analysis in yesterday's ruling in the Markson case. She looked toward the prosecutors and defense attorneys. Would counsel have any objection to Congresswoman Crockett submitting an amicus brief addressing the constitutional standards for protected political speech as they relate to this case? The defense attorney immediately stood. No objection, Your Honor. We would welcome such a submission. The lead prosecutor hesitated, clearly caught off guard by this unexpected development. After a moment, he rose as well. The government has no objection to an amicus brief, Your Honor, provided we have an opportunity to respond to any arguments raised. Of course. The judge nodded. Standard procedure for amicus submissions. She turned back to Crockett. Congresswoman, would you be willing to provide the court with your analysis? I want to emphasize that this is entirely voluntary and separate from the now resolved contempt matter. Crockett's composed expression gave way to a brief smile, not triumphant, but reflecting genuine appreciation for the judge's professionalism in re-evaluating her position. I would be honored to assist the court, Your Honor. I could provide a brief addressing the specific constitutional questions regarding the protection of political speech by the end of next week. Judge Howell nodded. The court would appreciate that. She checked her calendar. Let's schedule a hearing to consider the amicus brief and any responses for 3 weeks from today. As Crockett gathered her materials, something truly extraordinary happened. Judge Howell removed her glasses and addressed the packed courtroom. Before we proceed with today's scheduled matters, I want to make an additional statement for the record. The courtroom, already attentive, seemed to hold its collective breath. The proper functioning of our justice system depends on each participant recognizing their role and its limitations. This includes the bench. She paused, choosing her words carefully. The contempt power is perhaps the most significant authority granted to a judge, as it allows the judge to act as both accuser and adjudicator. That is precisely why it must be exercised with the utmost restraint and strict adherence to constitutional boundaries. Legal observers in the gallery exchanged surprised glances.